Is an adoptive mother entitled to maternity leave? The case for Carol Fern. Carol Fern is a union tax clerk employed with the Bainbridge Borough for 18 years. She was recently denied approval of 6 months unpaid paternity leave following the adoption of her 3-month-old baby girl. A rights disputes grievance was filed by the American Federation of State, County, and Municipal Employees, or the AFSCME, on her behalf. She is represented by an attorney for Local 10 of the AFSCME. An overview of this presentation includes the case review, the contract administration, the loyal employee, which is Carol Fern, the position description, my plan of action, my conclusion, and the references I use for this presentation. Carol Fern adopted a 3-month-old baby girl. In May, Carol asked for 2 weeks paid vacation, which was granted. One day before her vacation ended, she asked for maternity leave. The Bainbridge Council rejected requests but offered 2 consecutive 90-day reasonable purpose leave. In this case, contract administration can be used to resolve the rights disputes and aid in understanding why the bargaining agreement was not adhered to. John Budd, in the Labor Relations Striking a Balance textbook, defines contract administration as the process of interpreting, applying, and resolving conflicts regarding collective agreements. Contract administration includes rights disputes, which are the conflict over violations of rights specified in the collective bargaining contract. Disputes over rights can be done in a formal setting, and steps 1 through 4 of the typical grievance procedure notes exactly how employee rights and union rights and obligations are met. Step 1 consists of a verbal discussion between the grievant and the manager. If the grievant is unhappy with the outcome of Step 1, Step 2 leads to an appeal to a union representative. If the grievant is still unhappy with the outcome of Step 2, Step 3 is the good part for them. It is the resolution of the conflict, whether it is in favor for the grievant or against the grievant, which ultimately leads to Step 4, arbitration. The grievance procedures details the employee's rights to be heard, the union right to legally represent the union member, and the union obligation to live up to the terms of the contract as agreed upon by management and union representatives. In regards to union obligations, the National Labor Relations Act states that a union representative cannot refuse to process a grievance filed by a union member, and inclusive with this is the American Arbitration Association's acknowledgement that union attorneys have an equal stake in orderly, efficient, and constructive dispute resolutions. In an article written by Russell Pierce, he explains that unions have a duty to provide fair representation to process a grievance, whereby legal counsel furnished by the union is inclusive in employee rights. Miss Fern's work ethic and character is that of a truly loyal employee. After years of trying to conceive unsuccessfully, Carol and her husband decided to adopt. In April, when Carol found out that she had been awarded custody, her first thought was about the big workload she would leave behind. Carol waited until May 17th to have custody, using her 2 weeks for cleaning and organizing for the new baby. With Carol being a very loyal employee, It is my position to show that her rights as a unionized employee were violated when she was denied maternity leave. Since there was no union representative involved in the decision of her maternity leave denial or in the agreement of reasonable purpose leave, Article 5, Section 4.A of the collective bargaining agreement between Bainbridge and the AFSME was violated. The deliberate neglect of the collective bargaining agreement has also caused undue stress to Mrs. Fern. According to the National Labor Relations Act, union contracts are legally binding documents and assures the rights of unions, the employers, and the employees. The union contract specifically states that maternity leave, not to exceed 6 months, shall be granted at the request of the employee. The request for maternity leave is covered under the 1993 Family and Medical Leave Act, or the FMLA. In the article FMLA Gets a Facelift, author Morrissey notes that there were also changes to the law, but that employees were still allowed the 12 weeks of unpaid leave a year for the purpose of adoption. In a journal article written by Raphael Gelly and Timothy Chandler, they note that the purpose of the FMLA is to balance the demands of the workplace with the needs of the family, to promote stability and economic security, and should be done in the manner that accommodates the legitimate interests of the employers. Ms. Fern is entitled to maternity leave based on the detailed information in the legally binding contractual agreement between Bainbridge and the AFSME and the statutes of the federal laws. The plan of action that I choose to take is to ensure that the bargaining agreement contract is clear and understood between both parties, and to ensure that a union representative is included in all personal leave requests, approvals, or denials between Bainbridge and in the employees. Inclusive with this is that union representatives must ensure that they are accommodating the interests of the employer when maternity leave is also in question, and ensure that all contractual obligations are met. In conclusion, Bainbridge Borough did violate the collective bargaining agreement when they denied Carol Fern's maternity leave, and should ensure that all the collective bargaining agreements are accepted and understood by management.